I'd like to begin because it's a huge act, as we know, with all sorts of things bolted together, covering an array of things, only some of which are directly relevant to planning, but lots of things which may affect planning in due course. And so I thought it'd be worthwhile just giving you a quick overview of what is in force and in what way now, and what is later, because the overview that you've already no doubt been forming or heard other people forming is that the vast majority of the contents of the LURA aren't in force yet, and will require regulations, delegated legislation to bring it into force in due course. But if I turn to what is in force now, or will be in force 2 months from the date of the commencement, so just after Christmas, what we have in force now, or in that period, is the machinery coming into effect to start up the levelling up aspects of the bill. So again, will obviously concern planning, but won't directly affect any of the provisions of the Planning Act. The mechanics which underlie potential provision of combined county areas are going to have to start and will be in force in that period. So again, laying the groundwork through regulations and so on only, rather than the substantive content. Environmental outcome reports beginning their place in the system, making provision for the regulations to be made in that time. Slightly quicker action on nutrients, new duties being imposed on those concerned with sewage and undertakers in that time. Importantly, provisions to do with data in that time, information which needs to be provided, disclosed in a way, as we'll come to, which hasn't hitherto been the case. And then what I would, I think, fairly describe as a miscellaneous ragbag of other smaller points, some purely regulatory affecting RICS and Health and Safety Executive, smaller points in the scheme of things about ancient woodland and so on. So an indication of some things changing, and perhaps most importantly for landowners and developers and so on, some early changes in relation to completion notices, which are part of the new approach, as it were, by the government to trying to twist the arm, as they see it, of developers to bring forward housing more quickly. So we'll come back to that in more detail later on. In terms of not in force until regulations are laid, in other words, the longer term scheme, again, we have large scale changes in sight to the development plan and the advent of National Development Management Policies, NDMPs, in sections 92 to 4 of the Act. So they won't come into force until next year, and obviously we'll come back to the relationship between them and the framework changes in due course. Changes to the London Plan controls, changes to enforcement, 10 rather than 4 years, material variations to permissions. These are all matters which won't come into being until and unless regulations are laid next year. Completion notices, as I've said, will be enforced, but mechanics further to come. Changes to heritage, the infrastructure levy, awaiting, and perhaps will always await, further regulations, community land auctions, development corporations, and changes to CPO and compensation. So bearing those things in mind, I thought a quick overview of what one can draw from the short and the medium or longer term effects of the Act. It seems to me that in the next year, so in 2024 into 2025, there will be a reshaping to some extent of the system, and opinion differs, but mine is that there will be overall a likely shift to more centralisation, largely to do with changes to what's currently Section 38(6) of the 2004 Act and the advent of the NDMPs. There will be a scattering of provisions which may bring forward change, ease the system, nutrients in particular, perhaps. But the key will be the relationship between the LURA and the NPPF and what happens to that at the end of the year or the beginning of next year. A delivery on sites of all sizes for whatever use, but in particular housing, as a result, is likely to be less rather than more certain in the next year. It seems to me, and likely to lead to more applications and appeals rather than waiting. And I think one aspect of the next year is going to be what happens to the speed of local plans, something which I want to come back to with the panel later on, and whether there is yet further slowing, despite some of the provisions that we can see looming in the Act, in practical terms in the next year. If we think beyond the short-term effects to the longer-term effects, plainly one has to take into account political realities. The general election, a year away, perhaps, may already have happened in a year's time, is going to determine how much of the rest of the LURA is in fact implemented. Some of the tools which are in there, supplementing, changing things like development corporations and the combined county areas idea, which has the faint whiff of some form of sub-regional planning, may well be things that Labour or the Liberal Democrats, if they're in power, bring forward. Street votes, for instance, might happen under them as well, but they may well be overlaid, and it may be other parties that bring forward some of the regulations under the Act in due course. So it's difficult beyond a certain point to tell the final shape of some of those things. But if one assumes the whole package, it seems to me that what we have is a kind of recoalescing, a kind of fragmentation, recoalescing of the system in a form that maybe we haven't seen it before. And as I say, a real tension between the centre and the local aspects of the planning system. Undoubtedly a period of even greater instability, it seems to me, in the system beyond the general election. And just to take, for instance, EORs, environmental outcome reports, as an example, they have the potential to be much simpler and quicker. They also have the potential to be hugely problematic and longer and more indeterminate. Much will depend on the regulations. And so here, I think what we're doing is trying to assist you with thoughts towards participating in the system, making representations on regulations that are to come, and also thinking about strategic moves, whether you're in the public sector or the private sector, which could aim to deliver your objectives over the longer term. So I'm not sure it will be so much of a plan-led system if all of the things in the Act come to pass. But as we know, we're not sure how many of them in the end will. So that's a very brief overview of what's to come and what might happen. Before we turn to the next speaker, I just wondered whether the panel would participate in one question. I think that I've heard a lot of people asking at the moment already in relation to the LURA is what might happen to local plans in the short term. I've already said that I think that it will probably lead to some slowing down, but I wonder whether any of the other panelists, Rebecca perhaps, has thoughts about what the immediate impact in 2024, for instance, might be on local plans of the Act.
Yeah, thanks, Rupert. Obviously, the regulations aren't going to come into effect around Boxing Day like many of the others, and so it will time will tell what the government prioritise with regard to regulation drafting. And there's obviously a limited amount of focus for the parliamentary time coming up post-Christmas, and they will be in election mode, so they will be picking and choosing those things that are going to have the greatest impact for their prospects for election. My feel is that we won't see the amount of regulation, and also the MPPF changes have to be undertaken. PPG needs to be undertaken at the same time to address some of those local plan changes. So my feeling is during 2024, certainly for the first sort of quarter to half, we probably won't see much of a change in terms of the actual procedures. On the ground, though, I think we'll probably see more of what we're already encountering. So we're seeing a number of authorities start to withdraw their or slow down their plans. Some of them will be hoping that the new regulations will come into force quickly, because then they don't need to deal with duty to cooperate. Others will be looking at the likes of Coventry and going, well, if they can go with a shorter time frame and particularly the numbers, then we'll go with that just to get something on the books. So there's quite a lot of experience out there at the minute, which I think we will continue to see during the next 6 to 12 months. So I don't think there's going to be a massive change in the short term.
I think that's my view too, Rebecca. So certainly in terms of the paused plans and those that are currently, awaiting, we'll plainly have to see what the relationship between the framework is when it emerges and the system that we're looking at today. I just wondered, Nick, before we turn to yours, whether you've got anything by way of an overall reaction to this question of how local it will be, because obviously lots of stakeholders, including local authorities, keenly interested in the extent to which they retain control over the system. I know you're going to come to the changes to NDMPs and 38.6, but just as a kind of citer, do you think this system as it's presented in the Act is more local or less local than what we've got at the moment?
Well, I think it's trying to do both and probably not quite finding the balance to a certain degree. I mean, interestingly, I'm not going to talk about street votes, but it's a prime example where actually it's trying to be pro-development, give local people more control, but actually there's a feeling that probably it's going to become quite anti-development. It's going to be used in a negative way. So I think there's a balance between the two, but I think there's this view of let's make it look as if we're giving more power to the locals, but actually we're not. But we'll see, and we'll see how things progress.
Thanks. Now, Nick, you're our next speaker, and I think you're covering, aren't you, the nuts and bolts, if you like, the heart of the part 3 to the Act, where one finds some of the proposed changes to the development management regime. So take it away.
Yeah, so as I've said, I'm not going to talk about street votes, but I think there's an important point that's being made to me that there is a concern that will be used in a negative way by perhaps neighbourhood forums to actually restrict development rather than promoting it, which would restrict it more than permitted development rights. So it would supersede that. But we'll have to see whether that actually is used. It seems quite a complicated, long-winded process to make things happen, and obviously there needs to be referendums and processes to go through. But really, I think some of the key points coming in are the material amendments and variations to planning permissions. And this is being brought in very much in response to case law limiting on how one might deploy Section 73 variations to varied development. And as we know, it's being a little bit of a messy process where it's using Section 96A's to change descriptions, and then Section 73A to alter conditions also. So the aim of the Section 73B is to bring in a more streamlined, efficient process to grant planning permissions for development where they're substantially the same. I'll come back to this point about substantially the same in effect, because that will be down to some interpretation. The Section 73B, I mean, in one way, whilst it does create a more efficient system, it's fairly narrowly drafted. So it similarly won't allow extensions in time, nor will it allow for the disapplication of conditions relating to biodiversity, net gain, or the duty to provide progress reports on the scheme, which we'll come on to in a minute. There's one of the other points that have been made over time is how it responds to Hillside and the implications that have taken place on that. We know during the drafting there were recommendations made to try and revise the draftings so that it would pick up on the hillside. However, these were not taken forward. Consequently, there is concern that the power could be interpreted as being narrower in scope to existing power to amend conditions under the previous Section 73. And this, just picking up on this hillside, it may not be available in some situation in which dropping consents are most typically sought, i.e. replacing a land use with an alternative may not be deemed to be substantially the same in effect. So that's the issue, particularly in terms of interpretation about what substantially in effect means and how local authorities apply that. Just turning to commencement and completion notices, Rupert, you've touched on this already. So with commencement notices, developers will be required to submit commencement notices to local authorities specifying the date on which it is expected to be development is to be begun. And then completion notices, local authorities can, where they feel that development's being slow coming forward, they can serve completion notices, and that can lead to where their sort of powers come into force. Well, sorry, opinion that development will not be completed within a reasonable period of time, that planning permission will cease to have effect at a specified timescale. So a lot of this, I think, is the government's view about the allegation of land banking, and really to respond to that. Now, moving on from that point, there is also where a local authority feels that a particular developer across a borough is failing to complete development, they then have the power to decline to determine applications in cases of earlier non-implementation. I mean, it's going to be very interesting, this, whether local authorities will ever go down that route and whether it has wider implications, particularly in the world that we're in at the moment, where there's significant economic challenges that all developers are facing in delivering housing. There is, just going back to completion notices, there is where a local authority serves a completion notice against a developer, there is the power potentially to appeal that, and further regulations will come forward for that. But it seems quite a complicated process for local authorities, puts greater burden on their resources, and I suspect the reality is it will only ever happen in the most sort of extreme cases. But it will also be a good indicator to where we do hear this point about land banking, and we hear it in the news at the moment. There's been quite good documentaries on BBC about it, where allegations are made. It will be interesting to actually see whether evidence is provided that really shows this, and I think that's what the government are trying to show here. So just moving on, development progress reports. Again, this is part of the process, I think, very much to demonstrate to local authorities. This is going to be introduced as a mandatory condition to all planning permissions, requiring annual development progress reports to be submitted by developers. Again, quite how local authorities are going to have the resourcing to review that and have the technical expertise a lot of the time to interrogate whether that's right or wrong, we'll have to see. I mean, in many cases, we do see developers submitting that through Section 106, where they're required through construction management plans to progress this. So it's not a huge burden, I think, for developers to produce, but it will be, you know, it's another layer of, I suppose, bureaucracy for local authorities and admin to deal with. Just moving then on, as we talked about, environmental outcomes reports, which is essentially the reform of the current EU-derived system for environmental impact assessments and strategic environmental assessments, by introducing it in place of environmental outcome reports. As Rupert said, the aim of this is ultimately to reduce duplication and streamline the process for identifying and assessing the environmental impacts of plans and projects. We're going to have to see that, because it's subject to a lot of secondary legislation and regulation coming forward, and it could work in a really good way. It could streamline the process, but we've seen these changes before, so we'll have to see. What it does do is the Act provides the Secretary of State with the power to make a regulation which will specify environmental outcomes against which to assess relevant plans and programmes, and those outcomes will be subject to consultation. What we do know is that there will be, through the process, there's category 1 consents, which will require an assessment in all circumstances, and category 2 consents, which will require an assessment if the criteria set out in the regulations are met. We also know that the EOR must measure the expected environmental effects of a plan or consent against the environmental outcomes, set out the impact of any reasonable mitigation and compensation measures, and consider reasonable alternatives to the plan or consent. The other sort of point that the government have stressed within the bill, that the regulations will be able to amend, repeal or revoke relevant existing environmental legislation. However, the Secretary of State must be satisfied that the regulations will not result in a lower overall level of environmental protection, and that they're consistent with the UK's obligations under international law. So that's going back to what's always being said. It's not a regression on the standards. So that's sort of covering those points. Now, I have very quickly also, outside of the Act, just to remind everyone on the new fees order, this has now gone through Parliament, and we're sort of expecting this to come through this side of Christmas. Possibly it pops out on Boxing Day, if we're lucky. Something to read, but what it does do is it's increasing planning fees by 35% for major applications and 25% for all other applications, implements an annual inflation-related adjustment to planning fees, removes, what's interesting, the free go for repeat applications. And then there are other points relating to Crown land and also planning guarantees that we've talked about. So, yeah, that sort of covers the main points. The Act does cover quite a lot of other changes, but these are the fundamental changes that I think are going to really affect us through the sort of development management process. So I will, we'll wait for questions, I think.
Yeah, thank you very much, Nick. Indeed, we have had a few questions, and we'll just take some time to try and deal with a couple of those that people have been kind enough to post. I think there's a general point, Rebecca, that we can touch on at the end as well, but it's more, I think, than an observation, isn't it, in reality, about land banking and completion notices. I mean, there it is, but one of the issues, practically speaking, is whether in the real world this happens, and whether there'll be an easy appeal, if you like, against these things in the real world. Do you have any thoughts about that?
Yes, I mean, as most of our listeners will be aware, the Competition and Markets Authority have been undertaking a series of questions and what they're calling consultations before deciding whether or not they're going to actually do a full referral and investigation. And one of those has related to the land banking question, and it's long been debated, and Gove has had many fights with the house building industry over the last 12 months or so. And I think the push really is not so much about the land banking, although CMA will come to their conclusions. It's more about the how one is using land, and obviously speakers Richard and Jenny will come on to DevCorp, because that's obviously a means by which to facilitate, in the government's view, a way of fast tracking some of these sites which otherwise might have been considered to be land banked.
Thanks. We have a question which is an interesting one about the scope of these completion notices, Nick, or indeed anybody else on the panel, whether it's just about housing. I know that the political noise and intention has principally been directed, hasn't it, towards developers bringing forward housing developments too slowly, or housing-led developments too slowly. But does it go wider than that? Does it just talk about housing developments or development in general?
From my understanding, it's very much more about housing developments in the aim, and I think again it's clearly aimed at trying to deal with this point about land banking and get housing delivery moving forward. I think it's quite difficult to apply in the same way to commercial development. Yeah. It doesn't work in the same way for commercial reasons at all. So yeah, I think it's very much firmly aimed at housing.
Yeah, I think fewer people are conscious, even in a kind of general sense, about the things that drive, the bringing forward of commercial development and so on. Things that are coming forward quickly won't be caught anyway, it seems to me. But the idea that power could be used in relation to complicated, town centre mixed-use developments and so on seems to me to be extremely unlikely, given the need to show that there's unreasonable tardiness in bringing the thing forward. It just seems to me to be more a headline than anything in practical terms.
Yes, I mean, just to, at the moment, of course, it says it will apply to prescribed development, and obviously we'll have to wait and see what prescribed development is, but I agree with what's just been said. But there may be circumstances where other types of prescribed development could be called. Yeah.
And the scope of that will be an interesting discussion to be had with government when they bring it forward. But I think, as Nick says, it's housing first, purely housing first, much easier. Obviously, other things I think will cause significant challenges in the consultation on any regulations that come forward. Just one other point I think before we move on that has been raised, and that's it obviously at the moment awaits the detail in the regulations, but in terms of development coming forward which has been consented or is consented under permitted development rights, again, on the face of it, I don't think those are necessarily excluded, are they, from the ambit of this? I mean, a permitted development permission is a permission. It's a development. If you've got a big office to resi, for instance, then conceivably, at the moment anyway, as far as we can tell, that would be caught, wouldn't it, by this?
Yeah.
So it's more a question, I think, of the practical implications and whether the authority wants to, for instance, in some of those cases, because PD, by its very nature, may be something that the authority isn't particularly keen on having happened anyway. So whether, in practical terms, PD development would be caught, query. Again, it's a citer, I think, rather than a full answer at the moment for obvious reasons. Okay. I think that's that. Thank you very much, Nick. That was very useful. We're going to circle back, I think, to a couple of those things, particularly in discussion at the end. But let's move on. Let's continue this whistle-stop tour with Richard and your piece, please.
Thank you. So I'm going to deal with development corporations. So just.
I think actually, Richard, I think it's probably out of sync.
You first.
So
You're first. Yeah, you go first, Rebecca. Thank you.
Yeah, thank you. Good morning, everybody. So I'm going to cover a few of the high level changes, and many of these you will have probably been picking up in various journal articles and newspaper articles, but just to flag some practical points as well as we go through. So some of the key changes. So section 38, as we all come to know it, in terms of the balance between development plans and material considerations. So things that are affecting that, just to flag that the government is actually in the process of drafting national development management policies, and those will sit alongside development plans, and that will be the things that our applications will be tested against, unless material considerations, and this is important, strongly indicate otherwise. So that the insertion of the word strongly has been added through the LURA. that will have interesting implications, and a debate as to whether or not that will be interpreted such by the decision maker, or the courts will actually intervene. And that's a debate we'll obviously have as we go through. I think probably the former, that it will be a decision maker's balancing power on that one. In the event of conflicts, the national development management policies will trump the development plan, which is quite an interesting one. And so we'll all need to be very careful in our consideration and input into consultations on the DM policies. And as you'll all probably be aware, it's been a very controversial proposal that many local authorities have been quite put out by. And just a couple of other things, a new reference to supplemental plans. The minerals and waste plans are specifically referenced now in development plan definitions, and also the new policies maps, which is a part of the whole digital planning process, which is coming online. Climate change and local nature recovery strategies are both very prevalent in all of the drafting on development plans, and that's whether you're looking at spatial development strategies, local plans as we know them, and also anything that are relevant to the London authorities as well, the London plans. We'll have the need to mitigate and adapt to climate change. Well, we've already seen many local authorities starting to consider going beyond what the Environment Act is bringing into force on the 10% of BNG, and many of them, I believe Doncaster have already introduced in an adopted local plan a 20% BNG requirement. But obviously these things will continue to evolve as the environment and these particular policies take effect. And the recovery strategies, again, this is the reference to the BNG particularly. And I know that Natural England in some of their presentations recently have been suggesting that not only will they be documenting existing nature recovery corridors and assets, but we'll be looking to propose new corridors and areas that could be offered up for local nature recovery and biodiversity. So obviously something that we will all need to be very careful to engage with, because those won't be formally independently tested, yet they will be needing to be taken into account as part of the development plan process. Neighbourhood plans continue to be reinforced. Out is the general conformity with strategic policies in the development plan, and in being that the good side of things is that the neighbourhood plans can't have the effect of preventing proposed housing development in the wider development plan. And obviously we've seen some of that with some neighbourhood plans seeking to essentially disallow what the strategic plan has already considered. Local plan timetables. This is a new process, but also it's a nod to what we already have in the LDSs, but it's a more formalised process, and regulations will set out what has to be contained in the timetable, and more importantly, when they have to be revised. At the minute, as we all know, local authorities will take them back to their committees and update them, and it's quite an elongated process, and the consultations behind the LURA have been about how can we make that more seamless and quick responsiveness, rather than the chunky, sort of clunky LDS process. Interestingly, the London Mayor and the Secretary of State both have powers to amend the various local authority plan timetables. And despite the fact that we all think that the local authorities should comply with their LDSs now, there is a specific requirement that the authorities both publish and comply with their timetable. As to what happens if they don't comply with their timetable, the sticks and carrots that we've got now haven't particularly worked very well. So I wouldn't hold your breath to ensure that local authorities will actually comply with those timetables, but we wait and see. The actual procedures themselves, there's a lot of duplication between types of development plans and how they are set through in terms of their procedures set out in the Act. So these are high level points, but the drilling into the detail, there's, as I said, a lot of similarities. I think for me, one of the takeaway points is the fact that the local authorities have to seek observations and advice on their proposed local plan from a Secretary of State appointed person, and they are likely to have to pay for the luxury of doing that. Now, I think the words that people are using for that are the gateway checks, and this is of similar timescales to what we understand as the Reg 18 and Reg 19 timescales for when those checks would have to take place. Government have just closed the consultation on plan reforms, and this overlaps and dovetails with these LURA provisions and details the reality of how this will work. In terms of going forward, the local authorities have to publish and have regard to those observations and advice. And the other important thing is the authority must submit the local plan to examination if the appointed person or persons advise that prescribed requirements have been met. So it's an actual obligation to submit. The other counteract to that is the withdrawal provisions, and we've seen many local authorities whimsically withdrawing plans, particularly when we have change of colour of local government. And the withdrawing of plans, once submitted for examination, can only happen if the Secretary of State directs they can be withdrawn, or the inspector on their behalf recommends withdrawal. So less power to local authorities, which of course won't go down particularly well with many local authorities, but they will come to get used to that, I'm sure. And design codes, of course, have been long debated and have been prescribed to be included within those development plan documents. If we go on to the next slide, please. Final few things. Due to cooperate, really important, and long discussed, and is having an impact still now. So the Act through Schedule 7 repeals duty to cooperate. Now, it still exists in national policy. So the intention is to amend national policy to introduce what's been described as an alignment test. What that will actually involve, we're yet to see. And that will probably evolve further as we go along in the next few months. I'll come on to that a little bit more in a moment. Some new opportunities, potentially, the old age and disability guidance. That's the Secretary of State. This was debated in the Lords, particularly about the need for consideration of older person housing and disability housing. And this is the first time we've actually seen a specific obligation to publish guidance and how that has to be addressed during local plan and supplementary plan preparation. The policies map I've mentioned before. It's basically a geographical representation of all of the textual parts of the local plan. But really, the overriding point from the LURA on local plans is that there's a lot still to see, a lot of detail to come out through regulation and also guidance. If we can go to the last slide, please. Thank you. So what are the practical implications? So, I mean, if you're a developer out there and you're looking at how this is going to affect your budgets, well, you're going to have to allow for more engagement. There's a series of other documents here which you'll need to factor in because they could significantly affect your net developables, your budget costs for build, and so on. So design codes, supplementary plans particularly. Incidentally, on those supplementary plans, one would think they're similar to SPDs, but they've got this higher tier of ranking. They actually are the development plan, but they're not tested quite in the same way as the local plan. There is a presumption that that it's called a rule of thumb in the Act, that supplementary plans will only be tested by written representation as opposed to a traditional examination. So that one queries whether or not that will result in the sufficient degree of interrogation that one would normally see. Climate change and nature recovery strategies, as we said, look out for that because there's going to be more push by a number of councils to enhance what the Act has already said about BNG and probably other aspects as well. But what about contract timing? Rupert and I were debating at the top of this presentation about what will happen in the future. My feel is that if you're out there negotiating promotion contracts, hybrids or options, don't change. Just keep assuming the same long length of time because really there's no real new sticks and carrots to ensure delivery, whether we have a Conservative, Labour or a coalition government in the future. it's unlikely that there will be significant change in terms of how they really push things forward regarding compliance. In terms of the resource as well for Secretary of State, we've already seen the challenges that the Inspectorate have. So, a significant investment still needed there, but with a lack of additional resource in terms of funding available for those gateway checks. But in fact, those gateway checks have been happening through PINS. A number of local authorities have been using them, and they have been very useful. There's been a number of authorities in the southeast that have used them, and it has helped going forward. So I do see that as a potential upside, but it's going to take a long time for that to embed. So don't change timescales for now. Allocation fees, just a word on that, just best to avoid them. I think most people are at the minute, but because of the uncertainty about delivery requirements and the cascading potentially into supplemental plans. A few risks and opportunities there. I've mentioned a couple already, but I think overall, let's see how we go. But I think this could be a big opportunity, but I suspect, sadly, that the local plan process won't significantly speed up, certainly during the next 12 to 24 months. And I think the really important thing is just we need to, as an industry, be engaging with government and helping them, and also shadow governments, helping them to inform the DM consultations. If I can just, Rupert, I'm just going to pick up on the duty to cooperate. I know we've been debating it, and it was something that the panel have been discussing as well. And some of those on the listening in may be aware of the letter that Rachel McLean has just sent to Harbour. I know it's doing its rounds on various social media at the moment. And that was essentially saying that until 30th of June 25, that the duty to cooperate will still survive. Now, that's peculiar because obviously as soon as the regs come in to bring Schedule 7 of the Act into force, the duty to cooperate is essentially deleted from statute. So with the way we think the government is likely to pick this up is they will, if they bring into the force the regulations and DTC is formally removed, that they will continue to have this shadow duty to cooperate, working through policy for the period up to the 30th of June. And then thereafter, as part of their transition arrangements, that they'll transition into this new alignment test. So that's about all we can come up with. It's a peculiar suggestion from Rachel, and not one that we were all expecting, quite frankly. So I think I'll pause it there for a Q&A, Rupert.
Thank you very much, Rebecca. Really helpful. Just on that last point, I think if the intention with the remainder, if you like, of the NPPF is for it to focus on plan making, then I think it's almost inevitable that we're going to have, sooner or later, at the end of this year or next year, some further guidance on the DTC point and what remains of that in a revision to the framework. It would be pretty strange if it didn't do that, because obviously the existing arrangements in the framework will have to be varied or disapplied. So I expect something to happen in policy, as you say. Let's just pick up for a couple of minutes some points that people kindly have been raising on the Q&A. We won't be able to cover all of them, I'm afraid, but we'll try and pick up some of them. Just on the changes to the master provision, if you like, the 38.6 provision in the 2004 Act. A couple of points on that, I think. One is it in force now, if you like? I think that's relatively straightforward, I think. Does anyone want to pick that one up?
Sure, it's not. The answer.
Sigh of relief all around the country. So obviously
it needs commencement regs. Yeah.
It's got to wait for that to come in, and it's going to be tied in, obviously, to changes to policy. I think is the intention. So not in force, and answer that question at the moment. Watch this space. When it comes in, it changes the master section, if you like, including by insertion of the word strongly. And a couple of people have asked about this. I don't know, Jenny or Nick, just window dressing, ? Or is that going to have a real effect?
My view is probably just window dressing. I think the more fundamental change is definitely including national development policies in the assumption, and also the fact that they will trump the local development plan policies. Once you've got those in the assumption, generally, currently, the main material considerations which disapply the development plan are the NPPF. And they do quite regularly constitute a material consideration indicating otherwise. Of course, now they'll be, once they are adopted as national development policies, they'll be in the tent anyway, so they won't need to be material considerations strongly indicating otherwise to disapply the development plan. But of course, strongly is all a matter of judgment, all a matter of planning judgment, not a hard-edged term. It can be something can be strong for one person and weak for another, and it won't really make, I don't think, any material difference at all.
Yeah. In reality, people will still be decision makers, will still be reaching the same decisions. They're just hanging on the word strongly rather than formulating.
You just have to make sure that the officers reports it as strongly. Otherwise, there'll be scope for challenge. But once they're aware of strongly, it won't. I don't really think it'll make a lot of difference.
Yeah, and in terms of what's left with the NDMPs being of statutory force, if you like, in the front part of the statutory test, you're right. I mean, if the NPPF is really about plan making, there isn't much, is there? Material considerations are not the NPPF as in most cases these days, but obviously it's a wide open category, isn't it, into which all sorts of things, changes on the ground and so on, will continue to fall.
Absolutely.
Okay, let's just pick up a few more of the queries if we can briefly. There's a question I think we can deal with straightforwardly, which is EOR intended to replace EIA? I think the answer is yes, isn't it? To that,
yes.
It's a post-Brexit, isn't it? Change to replace with the domestic system the machinery that's coming from Europe. So the answer to that question is definitely yes. I don't know about commencement is. In section 255 is something that is you have to trace through, but section 73B somebody asks about, and whether that's in this 2 month, coming into force on Boxing Day or not, or whether it's just mechanics to bring in later regulation. Does somebody want to pick that point up? Is section 73 coming in on Boxing Day in force?
I don't think it is. I just had a look. I think because it's brought in, part 3 largely only comes in relation to making of delegated, making the power to make regulations, to the extent it comes in on Boxing Day. Other provisions come into force by commencement regulations. So I'm pretty sure, without just double checking, I'm pretty sure it doesn't come into force on Boxing Day.
Yeah, Jenny, that was my understanding, and I have to say, I think for all of us, there's a lot of confusion over it as well. But I certainly think it needs the commencement regulations to be brought in.
Yeah, I mean, just another point on the coming into force on the EORs and the EIA stuff. Whilst obviously we'll need regulations to flesh out what the EORs are going to be all about, on Boxing Day there will be revoked or omitted from the Town and Country Planning Act section 71A, capital A, which is the power to make the environmental type regulations, the EIA regulations, the habitats regulations. So that will be omitted from the 1990 Act. And the usual statutory presumption when an enabling kind of parent provision is revoked is that all the regulations under it are revoked on the same day. But I think there is some discussion as to whether that might leave a gap, basically, because you'll have the EIA regulations having been revoked and the EORs not in place. I don't think that is the intention. I don't think that it will be read that way, and I think that's because there's a sort of contrary intention point. And of course, the contrary intention in the Act is that those remain in place because there's an express power to revoke those EIA regulations as and when the EORs come in. So that's how it all, I think, will work step by step in my view.
Agreed. Before we turn to Richard, I just want to pick up a couple of other points that people have been making about completion notices, so that we can keep those in line. People have observed in their questions that viability might well be a reason to appeal against, or indeed for the authority not to make a completion notice. And I think that must be right, Nick, mustn't it?
Yeah, absolutely. I think that obviously there's a process where local authority will have to very, very carefully consider how they apply a completion notice, because obviously any developer will have the right to appeal, but I think it would be wrong for a local authority to be gung-ho about this. I did see some other questions sort of saying, well, don't we already have completion notices? But I think the difference here is, I would say there's more teeth to this, in the fact that what the local authority can do is, once they've served notice, they will set out in their notice to the developer that they would expect this development to be completed but within a certain prescribed time. If that development is not, then the planning permission will cease. So it does have quite a lot of teeth, and it is quite a powerful process.
I agree, and we don't have, obviously, in the current system, this ability, statutorily defined ability, for the authorities to refuse to deal with applications under certain circumstances by, as it were, underperforming or non-performing developers. That's a new aspect of the regime as well. Okay, well, we might touch on some of that again at the end, but let's move on. Richard, are you in play now for your slides? Thanks very much.
Thank you very much. So I've got a very brief slot on development corporations. This is obviously focusing on big ticket regeneration, garden communities, urban regeneration projects. So we've been engaging with DLUC and current government, and also with Labour. So this slide is just to indicate that actually there is quite a lot of cross-party consensus that Angela Rayner and Matthew Pennycook there for Labour are keen on development corporations, looking at a number of growth areas. They talked about 12 growth areas when they engaged with us, where they're looking at either centrally led dev corps where the local politics doesn't align, and locally led dev corps where the local politics does broadly align. And then obviously on the right hand side there, Treasury are going to take a view based on economic conditions. So the sort of promise of development corporations suddenly materialising in greater numbers than ever before does look as though it might actually happen, subject of course to how much cash there is in central government coffers. So if we just move on to what's actually happening in LURA. So there are now 5 rather than 4 types of dev corps. So there's the new towns, the new one, which is the locally led urban dev corp. So the central new town dev corp, the urban dev corp, the mayoral dev corps, and then the 2 forms of locally led dev corps, the new town one and the new urban one. So just to highlight what the new urban one's all about. This is all about setting a red line boundary for schemes that involve housing and employment. So rather than on a locally led basis, so a hybrid style dev corp dealing with brownfield, city town centres, new employment parks, and also, of course, you could include a new garden community or new settlement in one. They can be multi-authority area based. So you don't, have to confine yourself to one authority. And we know that Hertfordshire, for example, looking at one across multiple authority areas. Just as we have with locally led new town dev corps, then obviously the local authority consults and proposes what it wants. Secretary of State decides, oversight authority. Midlands Engine was heavily instrumental in lobbying for this new locally led urban dev corp. And there are various pathfinder bids, Tewkesbury, Sheffield, Carlisle, Milton Keynes, some other authorities who put pathfinder bids in for locally led dev corps. So watch this space, I think, on that. The various consistency powers for dev corp being brought into line with what's currently available for mayoral development corporations. How those are exactly bestowed, i.e. not all powers are always switched on for each locally led dev corp or central dev corp. It's a bit of a pick and mix, so you have to be quite careful to understand what's happening in your area if a dev corp's proposed. Important point now about CPO powers. the bill explanatory notes didn't really say much about CPO powers for DevCorps, but obviously Jen is coming on to talk about CPO in a moment. But I'll just mention the important provision on disapplication of hope value, which the government proposed as an amendment to the bill itself. Certainly in the DevCorp schemes I'm involved in, the promoters of DevCorps are looking carefully at this provision to say, well, we'll be in a stronger negotiation position to negotiate acquisition of land under the threat of CPO and then actual CPO if we can disapply hope value. The reality of it is that actually you can still establish value by planning permission and certificate of appropriate alternative development, and it's only if you can't that you get into hope value. But nonetheless, it's quite a significant provision, because if you have assembled land ready for development and a DevCorp suddenly comes along, then you're faced with the prospect of, have you done your deals correctly on gross value or net of affordable or net of schools or hospitals, which are essentially the provisions which Jenny will explain disapply hope value. So it's quite an important provision, and I've got a sort of practical implication slide on that in a moment. So you can just go back, Jasmine, sorry, just to, so borrowing aggregate limits removed and cap on board members removed. So the mechanics of these DevCorps, have been changed. Importantly, they can now borrow more, and they can have more flexibility on who's on the board. I mean, a classic example is, Michael Gove has obviously announced the Cambridge project and what needs to be accelerated in Cambridge, and this type of structure may or may not come forward as a result of that, for example. If we just move on to the next one. So practical benefits and risks and issues. So I think it's important to just be aware of it, to be honest, that we're going to see a lot more of them, locally led ones, more standardisation of powers, increased borrowing, simplification, that's all good stuff, more funding. Obviously, the benefit, if you're a landowner developer, of having a DevCorp, more funding opportunity. The risks are, we need more clarity on funding. So are they actually going to be properly funded? What's the role of locally led new town DevCorps? If you can actually do a sort of hybrid locally led urban DevCorp, why would you bother with a locally led new town one? Why not be more flexible and have different cash flows for town and city centre schemes and offsetting some of the long-term cash flows of new towns? Important points, as I've already mentioned, on hope value, potential strong-arm negotiations by DevCorps. So what I've been saying to clients is DevCorps can be your friend, but they can also cause you some difficulties. So just be careful to keep an eye on DevCorps in more detail. Delay risk to projects if DevCorps and interim vehicles are set up tends to be 18 to 24 months for them to get set up. So if Labour, for example, do become the next government and they push forward with DevCorps, then, looking at the timings of those, it could be quite important. Interplay with local authorities and Homes England. So should there be local authority input into a scheme or a CPO? Should it be a DevCorp? Should it be Homes England? They've all got powers, and the disapplication of hope value, for example, would be available to all acquiring authorities. And then the last slide, what should you therefore do? Well, if you're a local authority or a mayoralty, well, do consider your DevCorp options. Do engage with government, DLUC and Labour, business case productions, legal, financial, economic valuation advice, and obviously political engagement. If you're a landowner developer, again, engage what funding might be available to you. Homes England funding now bill available instead of HIF, but what could DevCorps add to the party? Do be careful looking at red lines. So it doesn't have to be a contiguous red line. DevCorps might be pockets of development in key target areas. It might not be a contiguous red line. Make representations about it, particularly if you're worried about this disapplication of hope value. And I'll just make a point about tying in with the planning data thing that Rupert talked about at the beginning of the webinar. Section 84 of the Levelling Up Act allows a local planning authority to require planning data standards for any purpose related to planning or development. And that could include previously hitherto information that was confidential in terms of options or promo deals that aren't on the public land registry. So there is, concern amongst some of our landowner developer clients that we might be seeing local authorities as well as acquiring authorities seek information on land ownerships that have hitherto remained confidential. And then consider JVs, so lots of DevCorps looking at JV opportunities as a way of getting public subsidy into projects on a JV basis instead of HIF and clawback or bill and clawback, and then engage politically locally, as I've said. So that's my little slot on DevCorps.
Thank you very much indeed, Richard. That data point, I think, which is obviously sooner rather than later compared to some of this material that we're talking about, I agree. Huge practical implications, I think, almost immediately. It swings in competitors accessing the information, impact on viability appraisals, how much can you redact, how much do you have to put in, all sorts of fences to be crossed on that one. Before we go, because I want to keep on time because there are a good bunch of interesting questions just to sweep up at the end. I want to make sure we try and cover as many of those as possible. I want to give Jenny her slot as well. There was just one point, Richard, I thought might be worth just picking up from your DevCorp piece. You mentioned Cambridge and so on. Obviously, in Cambridge is a good example of there being, obviously, if we're talking about hundreds of thousands of new homes, a good example of a place where anybody would need the widest possible array of powers, including the power to sort out the water, for instance, constraints that there are in Cambridge and the surrounding area. Do you have a feeling about whether DevCorps, as these locally led ones, are going to have the reach overall, or will it need some further iteration of legislation?
Well, it's an interesting point. If one deals with county council functions, it's actually quite difficult to get county council functions into a DevCorp, for example, to do with highways or guided buses or autonomous metros and that type of thing. We've been looking at it quite hard on a couple of projects, and there are potentially centrally led DevCorps, urban DevCorps, the ability to take on some limited powers. For water neutrality solutions and dealing with those types of issues on more stressed areas, they can't take on statutory undertaker powers, but what they can do is provide funding to accelerate that. So that's a collaboration, in essence, with water utility companies. So I know that lots of DevCorps are looking at that. Their remit, of course, is to accelerate development. So helping utilities deliver more quickly, on-site solutions, interim solutions, reservoir acceleration, those types of things, but also JVs, they're very keen to do JVs and have land value capture by JVs as a way of getting subsidy in rather than grant funding and clawback.
Yeah, I mean, it just seems to me that it's an example of this general phenomenon, I think, about kind of fragmentation of the system and changes, kind of shifting the emphasis going forward, if this all does happen in the way that the LURA sets out. But we can revisit that in due course. Let's press on. Thank you very much, Richard, indeed. Let's press on, Jenny, and have yours, and then we can do a sweeper session at the end and try and summarise some of the other points. Jenny.
Thanks, Rupert. Good morning, everyone. I'm going to start with CPO, which Rich has already touched on. There's actually quite a host of smallish changes to CPO procedure, which I'll run through in a moment briefly. But the main substantive change, which Rich has already touched on, is the ability to remove hope value. So Section 190 does insert a power for acquiring authorities to include in the CPO a direction which would remove the prospects of alternative planning permission being included as part of the compensation process. Now, that's not a complete carte blanche. It's only where the authorising enactment is as specified in Schedule 2A. And those are ones that relate to health, education or planning purposes. And again, only when those planning purposes include affordable housing. You can, the acquiring authority can apply for that effectively in the CPO, but the CPO will only be confirmed with that direction included if a number of conditions are met. firstly, that it has to be in the public interest for that direction to be made. And secondly, it's dependent on a statement of commitments, which the authority has to put forward, committing to do certain things that they say are in the public interest in relation to the project land. And the project land can include not just the acquired land, but also land associated with it that the authority proposed to use in association with it. So there is quite a stringent requirement on those commitments, which are to show that that direction is in the public interest, i.e. that no hope value is supposedly in the public interest. Contrary to some sort of toing and froing earlier, it will be a binary decision. So there's no scope for it to be part hope value, part not hope value, or part of the parcels in the CPO to be subject to hope value and part not. It either has that direction or it doesn't, which could have some unintended consequences. Another provision to be quite aware of is that if those statement of commitments, if those commitments are not fulfilled and not met, there is scope for the persons who've had their land acquired to go back and get additional compensation. That additional compensation would be the hope value that they would have otherwise been entitled to if they can show that the commitments have not been met. As Richard said, there's quite wide disquiet about this and whether it really will make any difference in terms of bringing forward affordable housing or other sort of beneficial developments, and the distortionary effect it's likely to have on investors making commitments to acquire land that may be in a regeneration area, may be subject to this disapplication of hope value, and how this could have a kind of chilling effect on some investment decisions. So it's we'll see how it goes, but it is quite fundamental and could change the market in ways that have not properly been thought through by those putting forward the legislation. So I'll just quickly then move on to the other provisions. And again, none of these are enforced yet, neither hope value or any of these provisions. They all have to be brought forward by commencement legislation. Just very quickly running through them. Some of these are quite important, but I don't have time to go into them in much detail. There will be an amendment to expressly include regeneration purposes as part of the 1990 Act power for CPO. There is quite a lot of provision about bringing CPOs and notifications online and streamlining that. There is changes to the procedure to hear objections, and appears to be a removal of a right to a public inquiry, although there will still be a right to be heard orally. There is provision for conditional confirmation of CPOs, which could, of course, speed up the confirmation of the CPO itself if it can be made subject to conditions that can then be met later or fulfilled later. But there is then provision for objections to be made to the decision to confirm that a condition has been discharged. So it's a kind of ongoing process, meaning that the actual implementation ability of the CPO may well be delayed, as far as a CPO may have originally been delayed if there have been no conditions. So it remains to be seen how much that would actually work in terms of speeding up the implementation of compulsory purchase orders. There's also a power to extend time for implementation, so there can be more than 3 years. Allowance for agreement to vary or postpone vesting dates, and amendments to the no scheme principle to ensure that the scheme, which is to be ignored, obviously, for compensation, includes the transport project, if there is one, facilitating the CPO development. So worth looking at those in some detail, but though quick run through. Now, moving on to something else entirely, nutrient neutrality. Where are we now? Well, the much discussed government amendment that was brought in at a late stage to the LURA, and which was designed to disapply the habitat regulations in relation to nutrient neutrality, that was defeated in the Lords, as we all know, and the parliamentary procedure, because it was an amendment, prevented it from being reintroduced in the bill, so it's not been made into the LURA. And I think we had a question on this actually, whether there's still scope in the LURA to bring forward something similar. I mean, the answer is no. There's no power or provision to disapply the habitats regs or to make assumptions in relation to the habitats regs as to nutrient neutrality, subject to the sewage provisions, which I'll come on to in a moment. But also it's worth noting that the announcement in the Conservative Party conference by Michael Gove that new legislation will be brought in the King's speech. There were then rumours that wasn't going to happen, and that was confirmed yesterday with the King's speech, where nothing about nutrient neutrality has been included. So the current position continues to be as set out in the recent High Court judgment in Fry, which interpreted the habitats regs in line with the EU directive purposes, and meant that pre-commencement conditions, even if they're nothing to do with ecology, can be held up by nutrient neutrality considerations if they're the last stage in terms of allowing development to proceed, and if that development has not been subject to appropriate assessment in the first place. That's the current position under Fry. That was granted permission by the High Court judge to leapfrog to the Supreme Court in terms of appeal. Supreme Court rejected that, but it is going to the Court of Appeal. Someone did tell me the dates of when that is. I've forgotten them, but maybe someone else knows. But that may be changed, but also perhaps more fundamentally, we've got the retained EU Law Revocation and Reform Act 2023 coming into force in January, which will change the assumptions around retained EU law and the effect that will have on interpretation of other legislation. So the basis on which Fry was decided may well be changed by the assumptions under the Act. And so if that kind of case was brought forward after that Act coming into force, then the outcome might be different, and that also may affect any appeal. So all things to watch, all quite complex things to watch. Just in terms of what else is in the LURA on nutrient neutrality, I mentioned before there's this issue about sewerage obligations. There are a raft of new obligations brought into the 1991 Water Industries Act, which place obligations on sewage undertakers to upgrade sewage treatment works where they discharge into sensitive catchment areas, and those areas would be designated by the Secretary of State as sensitive catchment areas, i.e. ones that discharge into sensitive habitats for nutrient purposes. Where those designations are made within 3 months of the Acts being passed, now that means 3 months from the 26th of October, where the designations are made within 3 months of that, then the upgrade date for the sewage treatment work would be 1st of April 2030. Slight wrinkle there because the actual provision doesn't come into force until Boxing Day. So in a way, there's only 1 month for the designations to be made, but I expect it wouldn't be that difficult to understand where these designations need to apply, given the position on nutrient neutrality is pretty well established where those areas are. So it's not an immediate short-term effect, 1st of April 2030. But the effect on habitats regs is that there is a required assumption, a deemed assumption, that upgrade will happen by the upgrade date, or by a later date if the designation is made later, but within about 7 years, meaning that on an appropriate assessment under the habitat regs, the assumption means that any concerns about adverse significant effects on habitats will be required to be allayed from that upgrade date, because of course the upgrade would then take away the potential harm from nutrients. What would be the practical effect in relation to that? I suspect that there may be conditions imposed on planning applications, planning permissions, requiring, for example, where there's this risk of harm or adverse significant effect advised by Natural England, if you have a condition requiring no occupation until after the upgrade date, albeit quite a way off now, then there would be the ability to conclude that there's no harm on the habitat, on the designated site, and to grant permission. So it may have some easing effect in the relative sort of short to medium term. Very quickly, sorry, biodiversity net gain. As we know, 10% biodiversity net gain, still not yet enforced from a legislative point of view. That's being brought in by the 2021 Environment Act. Positive net gain already a part of the NPPF, and as Rebecca mentioned, there are development plan policy requirements, some of which are already at 10% and some even higher than that. Joint statement in September said that BNG in the Environment Act won't be coming into force in November, but will be enforced from January for major sites, still April for small sites, and still 2025 for NSIPs. But makes clear that the transitional arrangements mean that it will only apply to to applications made after then. So applications that are already in process won't be affected. Draft guidance and draft BNG plan was published on the 26th of October. It's still in draft, but will be finalised by the time those requirements become mandatory. And in terms of what's already in the Act, Section 135 amends and adds to the provisions already in the Environment Act, which mean resetting the biodiversity baseline where activities undertaken after 25th of August 2023 have reduced biodiversity value, even if those activities have been undertaken pursuant to a planning permission since that date. If they've reduced the biodiversity value, that reduction in biodiversity value is effectively to be ignored for the purposes of the BNG calculation. And that, of course, adds to the provision already in Schedule 7A, which is also not enforced yet, but already in there, which resets the base biodiversity value back to 30th of January 2020 if activities reducing the biodiversity value have been undertaken without planning permission since January 2020. So very quick run through, but that's where we are now in terms of BNG. And I'll hand back to Rupert for a panel discussion. Thank you.
Thank you very much indeed, Jenny. Admirably compact, concise summary. I mean, it's a bit of a microcosm of the whole topic, as people will be appreciating, certainly by this stage of the webinar, even if you haven't read all of the Act itself. There's so much in it. I mean, it takes me back to the well-known legal fiction that we're always coming out with in court, that planning is a kind of comprehensive statutory code. Well, I mean, if that's true in any real sense, then my goodness, it's about as unmanageable a comprehensive statutory code as you can imagine with all of this comes in. So all sorts of different aspects. And this is going to be, I hope, helpfully slightly bitty, this last section, but I just want to mop up as many of the specific questions that people have asked as we can in the next 10 minutes or so to try and make this as practical as possible. Given the constraints of so much being left, obviously, to later in the process. And I wonder whether I could come, first of all, just back to you, Richard, on a question that's been asked about the ambit of DevCorps, locally led DevCorps, and the extent to which they apply to the mayor, the GLA, or to London boroughs. Have you managed to have a look at that?
Yeah, so, I mean, GLA can't implement its own locally led DevCorp, but obviously it can do its own DevCorp, mayoral DevCorp. London boroughs are actually caught because they are able to do that as a local authority in England, which raises an interesting possibility of London borough setting up its own locally led DevCorp, or with a partner London borough, and then who takes the powers, and how does that interrelate with GLA mayoral powers? Obviously, you have to apply to Secretary of State. And you have an oversight authority, which is local oversight authority. So the Secretary of State would decide what powers you would get. So that's an intriguing prospect in London. I can see one or two boroughs, particularly in political terms, if they're not aligned with the mayor, having a think about that.
Yeah, absolutely. Interesting, but thank you very much for that clarification. Just to pick up a point, Jenny, I know you've been talking until recently, and others can chip in as well on this, but there's a specific question asked about, a couple of questions asked about CPO. One is if you're thinking about CPO, compulsory powers, being used in terms of estate regeneration, whether it's going to have any of these provisions are going to affect the existing right to acquire, in other words, existing rights under other legislation. I mean, I had a quick look at this while you were talking. I'm not sure it does.
I don't think so.
No.
No.
So I think the answer to that is almost certainly not in the time that we've had to have a look at it. I think almost certainly not. Let's just jump back. It's going to be slightly bitty, as I say, to pick up on some of these points. In terms, Jenny, of nutrient neutrality, the interesting point you made about what the practical effects of the assumption about 2030 would be. I just want to come back to that, because that's a really, really interesting point, I think, of practical importance, kind of even now, if you like, almost even before the provisions fully come into force. Because again, thinking about the kind of Cambridge and water example, that's that's not in there. Obviously, we don't have a similar deeming, do we, in relation to anything of the nutrients. But if we just focus on the nutrient one, presumably, I don't know whether you agree with this, if one's applying for planning permission or on appeal, you can refer to this as a material consideration, can't you, in terms of what how a decision maker deals with nutrient neutrality?
I think so. I mean, what you mean before it comes into force?
Yeah.
I think you could refer to it as a material consideration, but I think it would be difficult for an inspector to carry out an appropriate assessment in reliance on it until it's in force, obviously.
Because of certainty.
Exactly.
Absolutely. Yeah, helpful. Thank you. The 10-year enforcement point, obviously, that's something which may be kind of shorter rather than longer term. Is it in force at the moment? Somebody asks. I don't think it is it?
No.
That's one that's going to have to wait. It's not in force, I think, either. When I say at the moment, it's not the 2-month Boxing Day timescale either. It falls within that whole category of things that need commencement orders under Part 3, I think, of the Act. Yeah. Nods all round. That's helpful. Thank you. Come back to completion notices again. Front end stuff, I think, Nick. Just maybe come back to you on these points. Completion notices and how they're really going to be used. We know how they've arisen, as it were, politically to be embodied in this Act. But somebody asks the sensible question about what happens if you're dealing with a scheme that the authority has opposed and it was granted, on appeal by an inspector or by the Secretary of State. To what extent a completion notice do you think going to be in play in relation to those?
I think there is a process from my reading of it that it needs to also go through the Secretary of State, if my reading's correct. So the Secretary of State, I think, has ultimate decision on deciding whether it's expedient to serve, to basically to cease permission. I think that's how I read it. But I think, it goes back to this point. Where completion notices are served, a local authority has to be very clear that they have compelling reasons for going down that route, because I suppose the implications are that if a consent is being implemented quite substantially, and then a local authority saying, well, you haven't completed it and therefore we're going to cease your permission, then there's a wider extent of implications that then surely they would need to then seek enforcement action because it doesn't have a consent. So it's quite a complicated process, but I can't see that. It sounds to me it's sort of being used by the government to show some teeth, but whether they actually really go down that route will be very rare. And I think the nearest I can think about it is really discontinuance orders, similar process to that, where there's quite a high benchmark sort of mark for where you would go down that route.
I agree, and I mean, people have asked specific questions about how this completion notice may work. Some of it's obviously going to have to wait a little bit longer before we find out the answer to that. But for instance, if as part of the outcome of these new provisions, the permission ceases to have effect, obviously it takes with it, as somebody rightly points out in their question, the conditions that apply, including the conditions that may apply to that part of the scheme which has already been constructed. Which is obviously something which may affect the usability.
Rupert, I think, there's section 93J deals with the effect of completion notices, and sub 3, for anyone taking a note, it says that normally planning permission, as you say, would become invalid once the completion notice deadlines happen. However, it doesn't affect any planning permission so far as relating to development carried out under it before the completion notice deadline. So I think the permission will still survive in relation to implemented development pursuant to that permission. So at least I know that one of the questions was about that particular point. So
it was. Thank you very much, Rebecca. 93J3. Obviously, we've been ingrained on our hearts for too long. It's an interesting one, isn't it? Because it'll be a kind of permission which exists for some purposes and not for others, which is not something that we're familiar with, I think, in this famous comprehensive code that we've got.
I suppose that's a bit like Hillside, though, isn't it? You know, when you've got, if you have a drop-in permission which makes the rest of the permission impossible to implement, then the permission still stands for what was done before that, but not after.
Good point. Yes, absolutely. Supplementary plans, somebody had an interesting question about. What are they exactly? Are they like, could they be thematic, akin to SPDs, or are they more site-based, kind of specific area-based things? At the moment, do we know? I mean, is it something that we're going to have to wait until we get the regulations on?
Yeah, if I take that one. So for people's benefit, Schedule 7 is often the place to go for development plan questions, and Section 15 C deals with it. For the London, the mayor can deal with use supplemental plans to deal with design or development of a particular description. But for every other local authority, it's about the amount, type, location, the timetable, a bit like an area action plan for specific sites, which is what I think the question was about. Also, the infrastructure and affordable housing for that site. The only other reference is specific references to design. So supplemental plans are likely to be used for design coding. And the catch-all is how the Secretary of State can prescribe other things over time, obviously, that the supplemental plans could cover.
Helpful. Thank you very much.
Rupert, I just wanted to mention, we haven't said anything at all, of course, about the infrastructure levy, Section 106 or SIL.
There is a question about that, isn't there?
A late question came in. I mean, I think it's fair to say, as we're out of time, that obviously, you know, if it were to come in, then it would come in over 10 years, government has said. If Labour get in, they've said that they're not going to take it forward. But clearly it's a highly significant topic in its own right as to how it would work. But I'm not sure we've got time to say any more about it, but that's why we haven't covered it in any depth today.
Thank you, Richard. And that's a general point that I was going to make by means of wrapping up, which I think we should probably move to given the time, that, as I said at the beginning, a lot of this, which is awaiting commencement or regulations, is going to be affected by political change, one suspects. And so it is moot, I think, the extent to which some things happen. At the moment, as you say, Richard, the infrastructure levy looks very much like one of those things that may not see the light of day if there's a change, certainly to a Labour or Labour-led administration. So I think that's a good example of the contingency, if you like, of a lot of the stuff that we've been discussing for people this morning. But let me do a couple of things now. One is just to quickly sum up, and then to thank the rest of the panel before we finish, and to thank the participants for their questions in particular. There's obviously a role in the next short period for further advice on and people looking at exactly when things come into force. I think the webinars tried to provide people with as much information about that as possible, but it's not easily seen on the face of the Act, and so I think we're all going to be trying to help you listeners and watchers with that aspect of things. And the Act is, I won't say ragbag because that's a bit too pejorative, but it's like the emanation is of all the dreams and hopes and fears and anxieties of the government expressed through the planning system over the last couple of years. And of course, that comes out in all sorts of different ways. And the completion notice point, which has attracted a lot of attention in terms of questions, is a very good example. It's seen, I think, as a kind of, a lever or a wrench or something for the system, but it's a potential spanner in the works, if you like, to change the metaphors, because unintended consequences of provisions like that are rife. So the other thing, of course, that underlies a lot of this is resourcing. And there are some points about fees and so on, but the system doesn't work a lot at the moment because of the terrible troubles that authorities have got in resourcing and funding themselves. And it's a little bit disappointing, I think, isn't it, that we haven't seen very much more on that in the LURA. Lots of expensive ideas that somebody will have to pay for, but a lot of people are scratching their head and thinking, who might that be? Let's hope it's not me. So I wrap up a major change subject to political purposes, some short-term stuff, and a lot which is the tip of the iceberg, and the iceberg may melt before it reaches the surface, I think, on some of it. But with that, may I thank very much indeed my fellow panelists. Thank you for taking the time and the effort to contribute. Thank you very much indeed for joining us, especially those who ask questions. And as usual, the detail of this, particularly those which are points which are applicable now, are things with which HGH, Pinsent and Landmark obviously stand ready to assist you with any questions that you may have in the short term. So thank you very much all. At this point, Jasmine, I think we'll call it a day. Enjoy the rest of your day, everyone.